dear learners and viewers. Today we will be discussing about the Bharatiya Nyaya Sanhita 2023 and we will be focusing on chapter 2 which deals with the punishment. So if you commit any crime, then what are the punishments which are prescribed under this legislation? And we say that this Bharatiya Nyaya Sanhita deals with the crime. So if anything which is an offense in India is there in the Bharatiya Nyaya Sanhita. So if we want to know that under the criminal law, what is a crime, then we will refer to the Bharatiya Nyaya Sanhita. Similarly, when we know that, okay, if I have committed a crime, what is the punishment, or this act is punishable under the law or not, then I will refer to chapter 2 of this legislation. So section 4 talks about punishment. So what kinds of punishment we can give under the Indian law? First is death. Second is imprisonment for life. Then imprisonment can be, of rigorous imprisonment, which includes hard labor, or it can be a simple imprisonment. Then forfeiture of property, fine, community service. So these are the kinds of punishment which the court can levy on a person if the person has committed a crime. So first is for serious offenses, death is also a punishment in India. Many a times, we have heard so many debates that whether death penalty should be abolished in India or the other parts of the world, because we are living in the 5th generation of human rights. But under the Bharatiya Nyaya Sanhita, we see a very prominent role that death has not been abolished in India. So for serious offenses, for habitual criminals, for heinous offenses, the death penalty is awarded. Second kind of punishment is imprisonment for life. So you can be imprisoned for rest of your life, and imprisonment for life is for 20 years. So if I talk about imprisonment for life, that means that you will be in the prison for 20 more years. Then third is it can be rigorous. Rigorous, when I say rigorous, it means that you have to do something, you have to do labor there, you have to work there, and you have to do some service there. And it can also include fine and then community service. As a part of religions, we find that community service is there. As lot of organizations are having community service. So if you commit a crime, then you will be working in the community and you will be serving people. That is also your punishment. And the other very important punishment is forfeiture of your property. So if you harm the government property, if you harm any person's property, then the court may award you this kind of punishment. So it is not that you can just walk anywhere, you can just burn the buses, the trains, you can lit stones on them. So it is not done. So if you are harming the government property, the private property or the public property, then your property can also be in danger. So these are the kinds of punishment. This is mentioned in section 4 of the Bharatiya Nyaya Sanhita. And when I talk about these punishment in details, you will understand that what kind of punishment is there in this code. Sorry. Section 5 talks about that the appropriate government, without the consent of the offender, commute any punishment under the Sanhita to any other punishment in accordance with section 474 of the Bharatiya Nagrik Suraksha Sanhita. So this is also very important provision, What is section 5 saying? That okay, these are the punishments which are mentioned under chapter 2 of this legislation, but any point of time Government of India feels that this should also be included as a punishment under chapter 2, then it can include under section 5. So section 5 gives the power to the Government of India to include any kind of punishment under the punishment chapter of the Bharatiya Nyaya Sanhita. For the purpose of this section, what is appropriate government has been explained. So, in cases where the sentence is a sentence of death or is for the offense against any law relating to the matter to which the executive power of the union extends, the central government. So, if the matter is related to death or any other punishment or any other crime which relates to the union government, then the appropriate government is the union government. If the matter is related to state, then the appropriate government is the state government. So it can be a case of death, or it can be a case of whether any offense has been committed under any law where the matter is with the state government. The executive power is with the state government. Then the state government has the power to make changes. So here is section 5, which talks about that you can include any one more punishment in the punishment chapter of chapter 2 of Bharatiya Nyaya Sanhita by this section. Section 6 says, in calculating fractions of terms of punishment, imprisonment for life shall not be reckoned as equivalent to imprisonment for 20 years unless otherwise provided. So I have already told you that when you calculate this punishment, then imprisonment for life should be reckoned as, it should be termed as, or it should be understood as that you will be serving in the prison for 20 years. Unless otherwise provided means that if there is a provision that okay, this person is imprisoned for life, but imprisoned for life in this section or in this code is for 10 years, for 15 years, for 7 years, then that will be applicable. Otherwise, if the act is silent or the section is not there, then we will have this belief that if I say imprisonment for life, that means it is for 20 years. Section 7 is also very important. In this chapter 2, when we started, I told you that it starts with chapter 4, section 4, and it ends with section 13. So, section 4 to 13 is divided into various parts. Section 4 says what kinds of punishment, can be awarded by any court under the law. Section 5 says that any kind of punishment can be included in this chapter 2. And what is the appropriate government has been explained. For any offense which is under the executive power of the state, it is the state government. For any offense which is under the executive power of the center or the union, it is the union government. Then section 7 says that in every case in which an offender is punishable with imprisonment, which may be of either description, it shall be competent to the court which sentence such offender to direct in the sentence that such imprisonment shall be wholly rigorous, or that such imprisonment shall be wholly simple, or that any part of such imprisonment shall be rigorous and the rest simple. So, whenever the court, declares that, okay, this is the punishment, then the court will only tell you that whether your punishment is simple imprisonment or it is rigorous imprisonment. I already told you that simple imprisonment is okay. For rigorous imprisonment, you have to work. So you have to put your labor there in the prison. Then it can be a mix of that. So few period you will be serving in simple imprisonment, and few of period of your sentence you will be serving in rigorous imprisonment. So you suppose you are imprisoned for 7 years, then the court will award the sentence and it will say that for 5 years you will be serving in simple imprisonment and for 2 years you will be in rigorous imprisonment. So that mention will be there in your judgment. Section 8, clause 1 says, where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited but shall not be excessive. A very important thing, in the country, you cannot say that, if you impose fine and I am not able to pay that fine, then whether that fine can be excessive? No. Whenever the court will award fine for punishment, then the court will have a reasonable jurisdiction. The court will see the person who has committed the crime, his, economic status, whether he is a habitual offender, whether he has committed a heinous crime, and accordingly will award fine. So it can be unlimited, but it should not be excessive. That is the criteria where the court will award the fine. In every case of an offence punishable with imprisonment as well as fine in which the offender is sentenced to a fine, whether with or without imprisonment, punishable with imprisonment or fine or with fine only, in which the offender is sentenced to a fine, it shall be competent to the court which sentences such offender to direct by the sentence. In default of payment of the fine, the offender shall suffer imprisonment for a certain term, in which imprisonment shall be in excess of any other imprisonment to which he may have been sentenced or to which he may be liable under a commutation of sentence. So this is very important. You cannot just put a fine which is, excessive in any case. Secondly, it should not be that if you are not able to give fine, then I just include your, stay in the prison forever or for entire life. It has to have a balance. So if I am not able to pay my fine, then the court says that in case you default the payment of fine, then also there has to be a reasonable jurisdiction wherein the court will allow you to be in the court and say that, okay, this is my economic condition, and when the jurisdiction is awarded and the punishment has to be declared, then the court will take into consideration your economic status, and if you're not able to pay fine after a particular period of sentence, then the court may award you further sentence. So if you have to pay fine and serve in the prison for 3 months, then what is the condition if you do not pay fine? If you have to be in the prison for 6 months as punishment, what will be the condition? We will be discussing further. The term for which the court directs the offender to be imprisonment in default of payment shall not exceed 1/4 of the term of imprisonment which is maximum fixed for the offence. So very important provision, the maximum period for which you can stay as a defaulter of not paying the fine is 1/4 of the term of imprisonment. So that is very important. The imprisonment which the court imposes in default of payment of a fine or in default of community service may be of any description to which the offender might have been sentenced for the offence. If the offence is punishable with fine or community service, now we have understood that 1/4 of the total imprisonment should be your exceeding limit if you are not able to pay fine. But suppose if you are not able to pay fine and to do your community service, then what is the provision? Then if the offence is punishable with fine or community service, the imprisonment which the court imposes in default of payment of the fine or in default of community service shall be simple, and the term for which the court directs the offender to be imprisonment in default of payment of fine or in default of community service shall not exceed 2 months when the amount of fine does not exceed 5,000 rupees. So, here they have given further bifurcations that what should be the maximum period of imprisonment and what is the nature of imprisonment. I told you, the imprisonment can be of 2 types. One is rigorous imprisonment and one is simple imprisonment. So in case where you're not able to pay fine, what kind of imprisonment you will have? You will have simple imprisonment. And what is the maximum period of stay in the jail is, 1/4 of your period of offense. So suppose the sentence is 7 years, then 1/4 of that 7 years will be the maximum stay where you can be allowed to stay in the prison if you are not able to pay fine or to do community service. Secondly, if the amount is not exceeding 5,000 rupees, then you can stay in the jail for 2 months. So the offense is that has been committed by you is of maximum fine which the court can impose is 5,000 rupees, and you are not able to pay that 5,000 rupees. So what the court will do, that you can be told to stay in the jail for 2 months, and that will be simple imprisonment, not rigorous imprisonment. 4 months when the amount of the fine does not exceed 10,000 rupees, and 1 year in any other case. So the maximum limit of your stay in the jail will be 1 year. The minimum can be 2 months, and in case the amount is 10,000 rupees, then for 4 months you can be in simple imprisonment if you are not able to pay the fine. The imprisonment which is imposed in default of payment of a fine shall terminate whenever that fine is either paid or levied by process of law. If before the expiration of the term of imprisonment fixed in default of payment, such a proportion of the fine is paid or levied that the term of imprisonment suffered in default of payment is not less than proportional to that part of the fine still unpaid, the imprisonment shall terminate. A very important point, Right now, I am not able to pay, but after a period of time, if I am able to pay my fine, then accordingly, my imprisonment will reduce. So this has been, explained by an illustration where I am supposed to pay 1,000 rupees fine and 4 months imprisonment in default of payment. So, if I am not able to pay, then the court says that for 4 months I will be in simple imprisonment. Here, if 750 rupees of the fine be paid or levied before the expiration of 1 month of imprisonment, A will be discharged as soon as the first month has expired. So, if I am able to pay 750 rupees in 1 month period, then I will be discharged as soon as the first month has expired. So I was supposed to pay 1,000 rupees. I was not able to pay 1,000 rupees, but as I have paid 750 rupees, so I will be discharged after the first month has expired. If 750 rupees be paid or levied at the time of expiration of the first month or at any later time while A continues to be in imprisonment, A will be immediately discharged. So, if 1 month has passed and still I am in jail and I am able to pay 750 rupees, then as soon as I am able to pay that amount, I will be discharged. If 500 rupees or the fine be paid or levied before the expiration of 2 months of imprisonment, A will be discharged as soon as 2 months are completed. So, you have to understand that if I am able to pay my fine, then I will be discharged as soon as I am able to pay that amount. Section 9 talks about where anything which is an offence is made up of parts, any of which part is itself an offence, the offender shall be punished with the punishment of more than one of such offences unless it is so expressly provided. So, if I have committed 2 offences, I cannot say that I will be saved, I will not be levied or I will not be punished for both the offences. I will be punished for both the offences. If I am committing several acts which constitute an offence, when combined a different offence, the offender shall not be punished with one or more severe punishment than the court which tries him could award for any one of such offences. So it will not be that, that if I have committed a crime, then I will be, because I have committed a series of crime, so I will be, given maximum punishment. It will never happen. I will be given the punishment which is as per the offence which I have committed. So, if I give a stroke to another person, this is the illustration, then I will not be, charged for 50 strokes. I will be charged for causing voluntary hurt to Z, and for that only I will get punishment. So it will not be that, I have given him 50 strokes, so I will be charged differently for every stroke. I will be charged only for the punishment of voluntary hurt. So, but if A and B have a fight and somebody intervenes and I hit him, then I will be charged for committing offense against A and to the person who has hit by me just because he came in between. So section 10 is also very important, which says, in all cases in which judgment is given that the person is guilty of one or several offences specified in the judgment, but that it is doubtful of which of these offences he is guilty, the offender shall be punished for the offence for which the lowest punishment is provided. So, the court will always say that whatever is the lowest punishment, if you're not able to make out that out of the several offences, what offences you should be punished, then the court will provide you the lowest punishment as per the law. Then section 11 says that whenever any person is convicted for any offence for which under the Sanhita, the court has power to sentence him to rigorous imprisonment. The court may by its sentence order that the offender be kept in solitary confinement. So section 11 talks about solitary confinement, and solitary confinement is, for the habitual offenders. And, there are following scales which are very important to understand. A time not exceeding 1 month if the term of imprisonment shall not exceed 6 months. Man is a social animal. So you will not keep that person in solitary confinement. You will have to, remove him from solitary confinement and put him in normal jail within a specified period of time. So that is mentioned in section 11. It says, if it is for 1 month, then it should not exceed 6 months period. If the time not exceeding 2 months, if the term of imprisonment shall exceed 6 months and shall not exceed 1 year. So, if this is imprisonment for 6 months, then maximum is that you can keep for 1 month. If the imprisonment is for 1 year, then maximum period for which you can keep is 2 months. A time not exceeding 3 months if the term of imprisonment shall exceed 1 year. So these are the criteria. Then section 12, in executing a sentence of solitary confinement, such confinement shall in no case exceed 14 days at a time. So, as I said, that man is a social animal. So you cannot remove that person from the society. You have to keep that person with other inmates. So you have to give him intervals between solitary confinement and you have to maintain those periods. When the imprisonment awarded shall exceed 3 months, the solitary confinement shall not exceed 7 days in any 1 month of the whole imprisonment awarded, with intervals between the periods of solitary confinement or not less than duration than such periods. Why do you think that this has been included? This has been included to protect that person's human rights. So, if you are saying that, okay, you are a habitual offender and you need to go in solitary confinement, then the law says that, okay, there is a timeline. So, if he has committed an offense for which the maximum punishment is 6 months, then this is the period of solitary confinement. If the maximum punishment is 1 year, then this is the period of solitary confinement. And if the maximum period is more than 1 year, then what the period of solitary confinement to take your property. So these are the punishments which the court can award if you commit any crime in India. And then these punishments have also been defined further, that if in case you are not able to do the community service or you are not able to pay fine, what is the maximum punishment you can get? So 1/4 of the period of sentence. Then if you pay fine, maybe 3/4 of the fine if you are able to pay, then whether you can be, taken away from the jail or you still have to stay in the jail. So it is very important that if for solitary confinement, which is very important in cases of habitual offenders, and in cases of people who have committed heinous crimes. Thank you all for this session. Have a great day.